The next set of conflicts deals with former clients. When do you have a situation where you have a conflict between a current or prospective new client and a client that you've already represented and the case is over? This is called successive representation. So Rule 1.9 of the Rules of Professional Conduct addresses this particular issue. Types of conflicts will almost always show up as a conflict when you run your conflict check, because you're going to have your former client now potentially showing up as an opposing party in a new case, or what is more likely, a former opposing party now wants to be a client. So there is a specific test that deals with this. Again, looking at the rules, an attorney cannot represent a person in the same or substantially related matter in which the attorney formerly represented a client whose interests are materially adverse to the person and about whom the attorney has confidential information. So first, just looking at the rule, you're looking at one, whether it is substantially the same matter. The case regarding the former client and the case regarding the new client. Is it substantially the same matter? That's the first thing. And then the other thing you're looking at is, are the interests materially adverse? Is the interest of your former client materially adverse to the interests of your new client? If those things exist, then that is a conflict of interest. And again, keep in mind that this also is dealing with confidential information. So the former client would be someone that we would have confidential information about. Former client can give informed consent to waive this type of conflict. Okay, former client can give consent to waive this type of conflict. So if it is in fact a conflict of interest, the attorney could decide it's a conflict, we're not going to take it. Or the attorney could decide it is a conflict, but I'm going to go to that former client and I'm going to ask for them to sign this waiver and give their informed consent. And that informed consent has to be very detailed, as we've already talked about. Okay. So a couple of examples. The first example, we represented Mary in a divorce against Tom. Case was completely resolved, no outstanding issues, no financial obligations. They've gone on their happy, merry way and have no legal ties to each other. Tom now contacts us. So he was a former opposing party. Now he's going to show up. Now he comes in as a prospective client. So he's going to show up as a potential conflict. And he wants assistance with a disability case. Do we have a conflict or can we take the case? So applying the test. Are their interests materially adverse? Are their matters substantially related? Okay. Are their interests adverse? By helping Tom in his disability case, are we doing anything to hurt Mary? Okay. Are we doing anything to harm her? Are we doing anything to lessen what we were able to assist her with in the divorce? Under these circumstances, no. There are no materially adverse factors here. Is there any confidential information about Mary that we're going to need to use or be tempted to use in the disability case? No, there's nothing about Mary that's going to be involved in the disability case. Are the matters substantially related? No, they aren't. They're completely different things. And again, nothing we do in the disability case is going to have any impact on the divorce case. Okay, so this is not a conflict. Okay, because it's not a conflict, we can take the case. We do not need, nor would we ask our former client, Mary, for a waiver. Because it is not a conflict, everybody in the office can work on this case. There's no restrictions or limitations. Okay. If this was a conflict, then the attorney, as I mentioned previously, could either just decline to take this case or could go to Mary and ask her to sign an informed consent and waive the conflict of interest. And if Mary was to do that, anyone in the office can work on that case. So that is the first example of how this works. Second example, we represented Mary in a divorce against Tom. Tom was ordered and is continuing under that order to make payments to Mary for the equitable distribution of property as well as pay her alimony. He now contacts our office for assistance in a bankruptcy case. Is there a conflict? Okay. So, like the first example, this will show up as a potential conflict because we have opposing party who's now going to be a client. But then we have to look at, are their interests materially adverse, and are the matters substantially related? Okay, are their interests materially adverse? By helping Tom in the bankruptcy case, are we in any way harming Mary or lessening what we did for her in the divorce? And the answer there would be yes. Equitable distribution is dischargeable under bankruptcy. So by helping him discharge all his debts, including the equitable distribution, we are then helping him not have to pay her, which is one of the things we assisted her in achieving under the divorce. So their interests are clearly materially adverse. Are the matters substantially related? On their face, they don't necessarily look like it because you have a bankruptcy and you have a divorce. They seem to be very different cases, but because some of the orders under the divorce is what's going to be involved in the bankruptcy and has to be discharged in the bankruptcy, they are substantially related. So this would be a conflict of interest. Okay. Because it is a conflict of interest, the only way the attorney can take this case is to go to Mary and have Mary sign an informed consent and waive the conflict. Without that, the firm cannot take the case at all. And the attorney may think better of it and just decide, I'm not going to take the bankruptcy case under these circumstances. So that is the test in dealing with former clients. So I tried to choose examples that were pretty straightforward, and hopefully they were straightforward. There are some that, can certainly be a little more of a gray area. Again, you do not have to make, as a paralegal, the ultimate decision. You just need to know when it is potentially a case. So, so you're sitting there with a client, a prospective client, and as you gather information, you realize we might have a potential conflict with a former client. You need to recognize that there may be an issue, so you know when to go talk to the attorney about it, and try to resolve this issue before we get in too far. Okay, so conflicts involving government officers and employees. There are special rules, and because of the area we live in, it is certainly possible that some of you are going to be working for the government or for agencies. So the rules are lawyer moving from government to private practice. So if the lawyer was an employee of the government or was a public officer and now is moving to private practice, the attorney cannot represent a private client in a case in which they participated on the government side. So basically, you can't switch from one party's side to the other in the same case. That would be a conflict. Now, if the government agency gives informed consent, then the attorney can handle that case. But I think that's pretty straightforward. If you're representing plaintiff in a case and you go to work for defendant, you can't just start representing defendant in that same case. But if they're moving from government to private practice and in front of that agency in other cases in which they did not participate while working for the government, that is not a problem. And if you have a situation where the attorney is a new hire moving from government to private practice, it is possible for that firm to continue cases they are already involved in. They would have to screen them, and that's what we're going to be talking about in class in much, much more detail. Now, if you have the reverse situation, the lawyer moving from private practice to government, basically it's the same thing. If you're representing a party in front of the government agency or office, and then you go to work for the government, you cannot be involved in that case unless the government agency gives its informed consent. And that's what the rule says. I don't know why it would be the government agency having to give consent. I would think it would be the former client that has to give consent. But that's not how the rules are written. And then the last piece of it is if a lawyer is serving for the government, they cannot be negotiating for employment opportunities with someone involved in a case in which they're currently working. So they can certainly move from government to private practice, but you cannot be negotiating during that time in which you're actively involved in a case against that attorney. Another situation, lawyers acting as arbitrators and mediators, completely allowed. It's called third-party neutral. The big caveat, and what the rule is discussing here, is that the attorney cannot be representing any of the parties in that arbitration or mediation, of course. And if the lawyer is aware of, or should be aware of, a party being under the impression that the lawyer is representing them in those proceedings, the lawyer has to clarify that they're working as a third party neutral and not as their representative. So really the rule is just dealing with the fact that if there is any confusion, the burden is on the attorney as the mediator, arbitrator, or third party neutral to clarify that with any unrepresented parties in front of them. And lawyer as a witness, generally speaking, we should not accept cases where we are going to be a witness. So we see an accident and then the party comes into our office and we know that's the accident we saw and we're potentially a witness. We should not accept the case. There are a few exceptions to that if it is in fact an uncontested matter. So if there basically is no opposing party or the parties agree and it's completely uncontested, then the attorney can take that case. The problem is we don't always know if they're uncontested when they first walk in the door. So in most cases, we're not going to see that situation. If the case involves the nature and value of legal services provided to the client. So this is basically the situation where the attorney is now going back into court to try to collect fees from the client or from an opposing party. The attorney is going to have to basically testify as to what work was done and how many hours were spent and all that type of information. That is allowed. So that would not be a conflict. And the last one is probably the one that's a little more confusing. If the attorney not handling the case would cause a substantial hardship to the client because of the client's or firm's distinctive value. So, I don't have a really good example for that other than something like, for instance, an asbestos case, because asbestos attorneys are far and few in between. And if they're a potential witness, but there's nobody else who can handle the case and it would be a substantial hardship for the client to go somewhere else, then maybe the attorney can take that case. Or maybe you live in a very small area, there's a very limited number of attorneys, limited access to attorneys, you might be able to make that argument as well. Okay, and then the last thing I want to talk about is not in the materials, but is important to understand that when an attorney has a conflict of interest, and they're already representing the client, they're already involved in the case, and the attorney discovers or realizes they have a conflict of interest, in 99.9% of the cases, the only way the attorney can fix it is to withdraw from the case. So it is really important that we catch these conflicts early on, which is why anytime you have a question about a potential conflict, you let the attorney know at the soonest possible time. Just because it is easier on the client, it's easier on the attorney, it's easier on us if we get out of that case sooner rather than later. It really is a hardship to the client if we're involved in that case and then we realize we have a conflict, we have to get out of it, and they have to go find a new attorney. This is also potentially an issue if you're representing co-plaintiffs and co-defendants. And it's not that it's automatically a conflict to do that. It can be done. But what the attorney has to be aware of is that at any point during that representation, if their interests become adverse, you're representing two co-plaintiffs, say in a car accident, and you realize as you get involved in the case that your plaintiff passenger actually also has a cause of action against your plaintiff driver of the vehicle as well as against the opposing party defendant, you have a conflict of interest. And the only way you can really fix that is to withdraw from the case entirely. You can't just drop a client and continue representing the other client. That does not get rid of the conflict because you still have the confidential information. And remember that conflicts is trying to prevent us from using intentionally or inadvertently confidential information about one client in the representation of another client. Had a student several years ago, worked for a criminal defense firm, and they would represent co-defendants. And when I was talking about this in class, she knows of situations where they were representing co-defendants, and midway through the case, their interest became adverse, and they would just drop one client and continue representing the other. That's technically not how you can fix conflicts. If you have a conflict, you are not to be involved at all. And if you have a conflict between your co-parties, you can't just drop one party and continue representing the other. You still have the conflict. That does not cure the conflict because you still have confidential information.